Hi, I'm Jason Neufeld with Elder Needs Law, and now we're going to discuss my top 5 Florida Medicaid planning mistakes. Let's get into it. Mistake number 5, relying on an outdated or poorly drafted power of attorney. I try to tell folks all the time, of all the fancy trusts that I do and documents that I prepare, a well-drafted power of attorney is by far the single most document I can provide to my client, because these free documents on the internet, or even ones that are drafted by attorneys who don't specialize in elder law or estate planning or Medicaid planning, if my client is not given the ability to have their agent do what we need them to do, they can't do it. And then they're looking at a much more expensive guardianship process. Mistake number 4 is failing to set up a proper qualified income trust or Miller trust. Medicaid has very strict income requirements, and they're counting all sources of income. They're looking at your Social Security, your pension, your 401k distributions, your rental income. They're combining all that together. And if it exceeds the income cap, you do not qualify for Medicaid unless you have a properly drafted qualified income trust. It's also a Miller trust. This is not a one-size-fits-all document. If you want to go to an experienced elder law attorney who can A, set up the trust and teach you and your trustee how to use it properly so you don't jeopardize your benefits. Mistake number 3 is failing to prepare for the possibility of the WellSpouse dying first. Statistics show that 30% of caregivers will pass away before the person that they're taking care of. And that's because it's an extremely stressful position to be in. So this has 2 implications. Number 1, who is now going to become the new caregiver for the one who needs long-term care, whether it's at home or overseeing their assets while they're in a facility? And number 2, if this person who's receiving Medicaid benefits unintentionally inherits other assets or money, it can unintentionally knock them off or disqualify them. So we can prepare for this in advance. Mistake number 2 is failing to reveal all your assets and income to the Department of Children and Families. So I want to tell you a quick story. I had a client who was a United States citizen, but was originally from Argentina. And they gave me all their United States bank accounts and assets and everything they had in country, and they did not disclose the large bank account they had that was still in Argentina, whether inadvertently or because they didn't think the government would find it. Well, Medicaid found it, and my client was not given these benefits. So my point is, whether you're working with me or any elder law attorney in the state of Florida, being truthful and disclosing everything is very important. And the number 1 mistake that Floridians make when applying for Medicaid is giving away their assets. The fact remains that Medicaid has an asset test. You can't have more than $2,000 to your name if you want to qualify for these valuable long-term care benefits. But the mistake that people made is they say my children or grandchildren are going to inherit this stuff anyway. Why not give it to them now so I can qualify now? But if you give assets away within 5 years of applying for Medicaid in Florida, you will be penalized. And the fact is, we have ways of getting assets out of your name and into the names of those you desire in a legal and ethical way that doesn't run afoul of Medicaid laws. I hope you found this video helpful, and I get it. This is complex stuff, and that's why I'm here to help. If you are anywhere in the state of Florida and are looking to access Medicaid's long-term care benefits, whether it's to pay for home health care, assisted living facility care, or nursing home care without going broke first, give us a call today.